Hey YouTube, this is VidHead85. Can we talk for a minute? Okay, so today I'm going to talk about the Perry versus Brown decision in 2011 and about how a lot of people kind of dropped the ball when they criticized the ruling. Now, after the Supreme Court vacated the Ninth Circuit ruling, a lot of activists were glad that the Walker decision was upheld, feeling that that was the best thing to do. However, the Perry versus Brown decision in the Ninth Circuit is no Freddie freeloader. See, after trying to find reactions to the Ninth Circuit ruling in Perry versus Brown, I ran across a law blog that pointed out something I never realized. Of course, being caught up in the moment, that Judge Reinhardt's ruling was a gold statue in a room where no one cared to marvel at it because of its silver base. Appellate courts are important because it's an intermediate court, and they're usually a step away from the Supreme Court or the highest court in the state. It has to rule on the facts of the case, follow precedent of their own circuit or Supreme Court. Contradictory rulings are usually held by the whole court, all judges hearing a case, which is called en banc. And 3, broadest abandoned, narrowest adopted. Reinhardt's decision, though vacated, gives us some legal gold nuggets. Now, right off the top of my head, 1, this establishes a case that this is not the first time that a constitutional amendment has been struck down, the Romer versus Evans case. You can't give rights and then take them away from a disfavored class. Let's remember Iowa and New Hampshire and their quick brushes that they've had with losing marriage equality. New Hampshire had a veto-proof majority and they were fighting for marriage repeal. It failed. Iowa could have lost marriage equality if they had a evenly split Senate, where alternate weeks would be given to the Democratic majority and the Republican majority. If Cindy Golden had won, the Republican had won, House Joint Resolution would have been adopted and cleared a hurdle and would need one more session to vote and repeal marriage in that state. Also, some Democrats had lent their voices in support of House Joint Resolution 6. That is why, even though this ruling was vacated, as if it never occurred, it still has some great pieces of wisdom that we can glean from it, all while staying within established precedent and keeping it as narrow as possible by ruling, 1, that adopting it to the specific yet similar situation of the Romer case, it was able to make a case that this is not something that is out of the box, unwarranted judicial activism. Romer started out in 1992 after Denver, Boulder, and Aspen, Colorado passed non-discrimination laws protecting gay and lesbian citizens from passed non-discrimination laws. Colorado groups put on an initiative campaign, and Amendment 2 was passed. Court action followed. The situations are similar, but Romer went a step further by prohibiting any governmental body from granting relief. That's a key difference, because Romer made the LGBT community strangers to the law, and that's the kind of hair that I split. Amendment 2 and Prop 8 made gays and lesbians strangers to the law. Proposition 8 said strangers to marriage law. In the legal world, placement of words could uphold or undo a legal argument or a ruling or reverse it, depending on the legal reasoning used by the presiding judge. So when taking a look at how they struck it down, notice how he says the designation of the word marriage. While they're still able to have all the legal rights in that state, or most comparatively, regarding child care and other spheres under California law, the equal protection claim kicks in a little bit, but is still covered under Romer because that is what Romer called out. Similarly situated except for marital status, even though it's still on that narrow read, but adherent to precedent or prior rulings. The blogger said that the Supreme Court would be wise to deny any review. I think it was a pretty easy case to take and dismiss on appeal without reaching merits. But Utah has forced an eye on the Supreme Court once again. Regarding the Ninth Circuit ruling, it has been vacated as if it never happened, and the Ninth Circuit has had to deal with all of the tricks that the proponents have pulled by trying to even vacate the district ruling, which was upheld under the Supreme Court, and the Ninth Circuit had no jurisdiction because the the standing part. But Reinhardt did his job. But for all the bluster of proponents of Prop 8, they failed to get the narrow ruling they wanted, yet they succeeded to a point. Yet with the trial court's ruling, sweeping as it is, the Ninth Circuit's ruling, the Imperiled versus Brown, is no chump. It's not the egregious, analytically wobbly and disingenuous as the critics of the time said it was. Now, before I recorded this video, I watched the AFER, American for Equal Rights video that talked about New Mexico and Utah and could they possibly be overturned. In New Mexico, this is a similar situation that could repeat itself if the legislature says that they want to put marriage on the ballot. This is, even though it wasn't done by initiative, it will basically be initiative, or it will be a referendum because the legislature passed it or referred it to the people. Even though it's not technically precedent, it is a constitutionally sound opinion whose argument should be adopted, and they could argue that in New Mexico court in the event that the state Supreme Court will hear it again should this happen. The critics snoozed on that ruling because it didn't go as far as they wanted to, but it goes far enough. When things change in a marriage equality state, with Republicans sweep in the next election, they could still point to the Ninth Circuit ruling, and Reinhardt's decision in Perry versus Brown will endure the test of constitutionality. So in other words, it can technically be adopted even though it was technically vacated, but it still has enough legal weight to maintain its argument and argue it well. Thank you for letting me talk to you, YouTube. I'll see you later.